From its inception, the American Constitution has been understood not just as a list of powers and prohibitions, but as a system of structural restraints, a deliberate architecture designed to preserve liberty by restraining power. Among the most potent dangers feared by the framers was the standing army, a permanent, centrally controlled military force operating in peacetime. To modern eyes, such forces are normalized, an unquestioned element of national governance. But for the constitutional originalist, this normalization masks a profound deviation from the document's intended structure. The originalist approach insists that constitutional meaning was deliberately shaped by the founders, informed by the public understanding at the time of ratification. It takes seriously the legal assumptions, political fears, and design principles that shaped the document. In this light, the issue of standing armies must be viewed not through the lens of current policy preferences or national defense necessities, but through the lens of what the Constitution was meant to authorize and to prohibit, based on its language and historical context. In the late 18th century, standing armies were not seen as neutral administrative tools. They were regarded as an inherent threat to liberty, even under civilian control. This judgment was not speculative. It was grounded in the English experience of the 17th century, where monarchs, particularly the Stuart kings, had employed standing armies to intimidate Parliament and enforce absolutist policies. The very presence of such forces in peacetime became emblematic of tyranny. The Glorious Revolution of 1688 and the subsequent English Bill of Rights codified the principle that standing armies should not exist without legislative consent, and even that consent was intended to be temporary, contingent, and highly scrutinized. For American colonists, these lessons were not merely inherited, they were lived. British troops stationed in North America were experienced as occupiers, not protectors. Their presence inflamed tensions, eroded local autonomy, and became a visible symbol of imperial control. The Declaration of Independence gives these grievances constitutional weight, explicitly condemning King George III for keeping among us, in times of peace, standing armies without the consent of our legislatures. By the time the Constitution was drafted, this experience had crystallized into a shared political assumption. Standing armies, especially in peacetime, were seen as incompatible with republican liberty. When the Constitution emerged from Philadelphia, it did not expressly ban standing armies. But interestingly enough, neither did it affirmatively authorize them. The power granted to Congress is to raise and support armies, a phrase that is inherently conditional and episodic. It suggests the creation of forces in response to needs, not the maintenance of a permanent military bureaucracy. Tellingly, this power comes with an explicit constraint. No appropriation for the army may last longer than 2 years. This is a singular limitation. No other enumerated power in Article 1 contains such a restriction. That specificity speaks volumes. It suggests not procedural formality but substantive intent. Importantly, this limitation is not paired with any similar constraint on naval appropriations. The Constitution empowers Congress to provide and maintain a navy without reference to a temporal cap. This deliberate asymmetry reflects a founding-era consensus. Navies were primarily defensive, facing outward, securing commerce and coastline. Armies, by contrast, were domestic by nature and coercive in potential. Their presence among the people, especially in the absence of active conflict, was seen as corrosive to civil liberty. The design difference between these clauses reflects this foundational judgment. Further evidence of the intended military structure lies in the Constitution's treatment of the militia. Far from being a mere supplement to a federal military, the state militias were expected to serve as the primary armed forces of the Republic. Their organization and control were partially federalized, but their leadership remained fundamentally in state hands. Congress could prescribe discipline and call them forth in emergencies, but officers were to be appointed by the states. This decentralized design ensured that military power could not be easily consolidated at the national level. A permanent, centralized army would invert this entire logic. This design was not hidden. It was defended publicly by the Constitution's most able proponents. James Madison, writing in Federalist 26, acknowledged the dangers of standing armies, but pointed to the 2-year appropriations limit as a critical safeguard. The premise was that each reauthorization of military funding would require political will, public debate, and electoral accountability. Every 2 years, the people could remove representatives who acted contrary to Republican principles. This was not a procedural delay, it was a structural defense against entrenchment. The entire system was premised on the idea that reauthorization should be neither automatic nor inevitable. The broader logic here is anti-entrenchment. The founders were deeply wary of any institution, military or otherwise, that could outlast the periodic judgment of the electorate. A permanent military presence creates momentum. Bureaucratic inertia, strategic commitments, and political dependencies that make defunding practically impossible. If military reauthorization becomes a mere formality, then the 2-year clause has failed in its purpose. The constitutional mechanism has been preserved in name, but nullified in practice. Modern legislative behavior compounds this problem. Statutes may technically expire after 2 years, but they frequently embed military programs, personnel structures, and procurement systems that assume continuity. The structure of military appropriations today is layered, recursive, and self-reinforcing. In this environment, the nominal reauthorization every 2 years does not reflect independent deliberation. It reflects institutional dependency. The political costs of disbanding or significantly altering the armed forces are so high that the prospect is rarely entertained. The result is a standing army in all but name. This raises a deeper constitutional problem. What exactly is being regulated by the 2-year clause? If each appropriation is viewed in isolation, the continuity of military force is obscured. But the Constitution does not merely regulate statutes, it constrains conditions. A standing army is not defined by whether any one bill creates it. It is defined by its permanence, its presence in peacetime, and its independence from emergency. These are empirical facts. If the armed forces exist continuously, funded without serious interruption or threat of defunding, then the constitutional line has been crossed, not by any one act of Congress, but by the sustained reality. Judicial doctrine has largely declined to address this constitutional breach. Courts have invoked principles such as the political question doctrine and separation of powers to avoid entanglement. They treat each appropriation as a discrete act, declining to aggregate their effects or consider the structural implications of continuity. But this approach reflects judicial lawmaking, not constitutional fidelity. From an originalist perspective, the Constitution's meaning does not hinge on any court's interpretation. Even where the judiciary has allowed its violation, the original meaning must still be defended by all who take an oath to the document. Supporters of the status quo may argue that repeated reauthorizations of the military reflect democratic consent, but this argument misses the point of the 2-year constraint. It was designed to disrupt normalization, to prevent dependency from becoming destiny. Consent that emerges from structural compulsion or political inertia is not the kind of deliberative consent envisioned by the framers. Others may argue that the Constitution plainly permits Congress to raise armies, and that the 2-year clause merely imposes a limit on the duration of any single appropriation. But such a reading flattens the careful distinction between raise and maintain, and ignores the specific fears that animated the clause's inclusion. Still others might observe that the Constitution is silent on permanence, and from that silence infer permission. But in the context of known abuses and deeply embedded fears, silence does not imply neutrality. It signals constraint, achieved not through categorical bans, but through design choices intended to channel and limit power. The 2-year clause, the asymmetry with naval appropriations, the primacy of the militia, all point toward a structure in which armies exist if needed, but not by default. Viewed through this lens, the modern standing military is not a vindication of constitutional design, it is a departure from it. It reflects political accommodation, judicial activism, and institutional capture, not original meaning. The Constitution permits temporary armies, subject to regular, meaningful reconsideration. It does not license their perpetual presence. What we live with today is not a constitutionally authorized institution, but an unconstitutionally tolerated practice, one that survives by virtue of political habit, not textual warrant. For the originalist, this is not merely a matter of semantics, it is a matter of fidelity to the document, to its structure, and to the liberty it was crafted to protect. The standing army, once regarded as the hallmark of tyranny, is now a normalized feature of American government. But normalization is not justification. The Constitution's meaning remains. And by that meaning, the standing federal military in peacetime stands on contested ground, not grounded in original design, but persisting only through legislative inertia and political expediency.